Hello, and welcome to the first legal scoop of the new year. I'm Brendan Shannon. I'm an associate attorney here at the law office of Melissa Day, and I'm here to talk about a recent win that we had here at LOMAD. And my guest for today is actually me. I'm going to talk about a disallowance that I had where we had a fact pattern that I'm sure a lot of people are familiar with, which is a claimant who was traveling to work for the day when she fell and was injured. Basically, the facts of this case are that the claimant worked as a home health aide, and she had two patients every day. Now, for those of you who don't know, the law here basically states that where someone worked at a fixed location or multiple fixed locations, they're not covered by comp when they're traveling to work or to that patient or patient's home, home or homes. Now, where it gets a little bit more nuanced, that there are home health aides who have multiple patients throughout the day and that their patients vary. In other words, they're not traveling to a fixed location. They're traveling to different locations with no real regularity to it. Now, in this case, as I stated, the claimant had two patients per day, and these were her regular patients. They lived in the same residence. They didn't move during the time that she was seeing them. And on top of that, she always saw the morning patient in the morning and the afternoon patient in the afternoon. We argued that basically the claimant was what's known as a hybrid employee. As a hybrid employee, she is considered an inside employee when traveling from her home to the first patient's home, as well as from the second patient's home back home. So basically when she's commuting. However, she'd be considered an outside employee, as in someone who's covered by workers' compensation coverage while traveling, when traveling between the first and second patient's home. And in this case, the employer actually paid the claimant accordingly. They paid for her travel between patients' homes, the two patients that she saw every day, but not for her commute. So we argued that she was, again, an inside employee traveling to a fixed location as she fell while traveling to the first patient's home. The court agreed with our position. However, there was another issue here. So while the court agreed with our position that she was an inside employee not covered by comp while commuting to work, there was still an issue of whether she had actually reached work at the time that she fell. So in this case, the first patient lived in an apartment complex with, presumably close to 100, if not more, a little bit less, people living in the building. And her testimony was that she fell on the curb near the entrance and near the stairs to the entrance. So we argued that in that case, she had not entered an area that was unique to her employment as a home health aide taking care of this woman. So basically the law on this issue is that for it to be compensable, the claimant needs to be exposed to a special hazard that's, again, unique to an employee. It can't be something that the general public's exposed to. Now, the claimant was very clear, and we even directly asked her if she was still in a public space when she fell. And we also had case law with a similar fact pattern where it was basically stated that since the claimant fell in a spot in an apartment building or near an apartment building where she could have accessed any apartment in the complex, that would make it so that she was not in a unique location that was a special hazard, that only she as a home health aide for this patient would be exposed to. And again, the judge agreed with our position, as it was consistent with the law, where you know you're not covered. I mean, despite the fact that you're close to your patient's residence, you're still in an area where anyone in the general public could potentially be at risk of tripping on that curb, landing on the sidewalk. And it's not unique to her employment as a home health aide for the first patient. So we got a disallowance on that, and we are very excited by that win. That's why I decided to interview myself this month. Please, if you like the Legal Scoop, it's our video series where we talk about recent wins here at the Law Office of Melissa Day. Please subscribe to our YouTube channel, and if you want to get more video content, we also have a video series with Melanie Daly, the legal grind, or the daily grind, excuse me. And we have a newsletter that we send out. You can email hearings at Get Mad today, and we will get you signed up on our VIP list. Thank you.